Persons convicted of crimes are subject to a wide variety of restrictions and disqualifications that are frequently more punitive and long-lasting than the sentence imposed by the court. Even minor offenses trigger serious and potentially life-altering statutory and regulatory penalties affecting a convicted person's livelihood and status in the community. These so-called collateral consequences of conviction are scattered throughout the codebooks and are difficult to identify, and they're frequently ignored during plea negotiations and at sentencing. Technology has made it easy to access criminal records, and there are few limits on their use to exclude and stigmatize. Given the number of individuals affected, it is easy to see how collateral consequences have become an increasingly important part of civil practice areas as diverse as employment, civil rights, government contracts and benefits, immigration, and family law. In recent years, encouraged by Supreme Court decisions, the bench and bar have begun to recognize their responsibility to consider collateral consequences within the criminal case itself. This book is the first attempt to address, in a comprehensive fashion, the range of legal and policy issues raised by collateral consequences. It surveys the many different types of consequences, reviews constitutional and regulatory grounds for challenging their application, and describes ways of avoiding and mitigating their effects. It is intended to provide practical guidance for criminal law practitioners and civil practitioners in many different practice areas, and includes review of recent law reform proposals that will make it easier to understand and manage these secret sentences.
I teach a criminal defense clinic, and my students are constantly dealing with the collateral consequences of their clients' convictions. For prosecutors, defense lawyers, and judges, the book offers an overall landscape of the many varied ways a criminal conviction can affect the life of an individual, from the types of consequences that flow from a conviction to the real meaning of a criminal record. This helps those in practice and those facing criminal charges understand the true consequences of a criminal prosecution. The book goes through each stage of the criminal case to explain the different ways collateral consequences arise in practice, from charging decisions to sentencing. At a time when individuals' criminal records are easily accessible, collateral consequences should be taken into account at each stage of the case. This is not just a book for criminal law practitioners. Civil practitioners can use the book to help clients who are or have been involved in the criminal justice system. There are 70 million individuals' fingerprints in the FBI database, and almost 100 million in the databases of the states, territories, and the District of Columbia. Long after the criminal case is over, civil practitioners need information about how to help clients avoid or mitigate collateral consequences of a criminal case that may be many years in the past. This book does what good criminal law and civil practitioners do in everyday practice. Pay attention to the whole client, to all of the important consequences of contact with the criminal justice system for that client, consequences that extend well beyond the criminal courthouse doors.
Collateral consequences don't just matter to people with criminal records. They matter to everyone. Disenfranchisement changes the outcome of elections. Limits on employment affect the economic vitality of neighborhoods. And restrictions on financial aid, access to housing, and occupational licensing exacerbate pre-existing racial and social class disparities. Some collateral consequences make sense. They improve public safety in ways that are fair. But others impose burdens that are not offset by their benefits to society. This book outlines the full range of ways in which people who have served their sentences continue to be affected by long-past criminal offenses. Doing so helps make these invisible punishments more visible in ways that we hope will help promote thoughtful reform. The good news is that lawyers and lawmakers are becoming increasingly aware of the problems caused by excessive collateral consequences. The U.S. Attorney General has called on state officials to revisit their state codes and to repeal unnecessary restrictions. And groups like the American Bar Association and the Uniform Law Commission have proposed ways in which judges or other designated decision makers might be authorized to grant relief when appropriate. A few states, like Ohio and North Carolina, have even passed laws making it easier for people with criminal records to find work and to reintegrate into their families and communities. We are confident that these efforts are just the beginning of a move toward greater transparency and more careful legislation in this too long overlooked area of law. This book is a resource that engaged citizens, lawyers, and lawmakers can use in their efforts to advance much needed legal reform.